And to start the event, I would like to introduce our first speaker, Jonathan Shaw, who is a barrister at law at Corporate and Chancery Group. Jonathan?
Can you hear me?
Yes.
Okay. Well, I want to start this short talk with a question for all the participants, and I want you to consider carefully how you would answer the question. I want you to imagine you're sitting at a dinner party with 8 people, and it's very congenial, conversations flowing. And then all of a sudden, your host, who happens to work for the OECD, asks you, how much do you earn a year? You're rather taken aback by this. And there's two ways of answering. You can either lie and tell him you earn 20 million a year and shut him up, or you can tell the truth and say, I'm sorry, that is personal to me, confidential. And before you could move on in the conversation, the OECD host's wife pipes up and says, well, how much tax do you pay a year? And again, you'll probably give the same answer. You'll say it's confidential and it's private. And before anybody says anything else, a chap speaks up at the end of the table and he says, well, look, in my country, everybody's income is available to view online, and all their tax returns are available to view online. I'm from Norway, and this chap's from Oslo in Norway, where in Norway, everybody can see everybody else's income statements for the year and their tax returns for the year. I don't know if this may be a bit of a shock to people, but I was actually quite amazed when I heard about this. However, it's not some incredibly terrible rule that's been brought in by the EU or by the OECD. It is, in fact, it's been the law in in Norway for 200 years. 200 years. They've been snooping around on everybody else's tax returns and income statements for a long, long time. However, it did change in 2014. And if you wanted to look somebody's income up online and their tax returns online, then you had to give your name and address, and whoever is being investigated by you, more like being a nosy Parker, your information goes to the person that you're looking to see the annual returns for. So they found that after 2014, the amount of nosy Parkering reduced by about 85% because people didn't like to be known as a snooper on their neighbours. Now, this is a very interesting concept because Norway is the only country in the world that does this. And the reason why it's a very unusual case is because that's particular to that particular country. Everybody else in the modern world, I'm not saying Norway's not modern, but I'm saying in today's world where we all live, we pride ourselves on our confidentiality in the fact that people don't know what other people earn, they don't ask, and they don't tell. And that is perfectly normal. Not, however, to people in the EU or people particularly in the OECD. The OECD and the EU have been waging a war on confidentiality. And this has been going on. Well, it first started, of course, in 2010 in the United States. I'll give you a quick thumbnail sketch. In the United States, they had the Foreign Account Tax Compliance law that came in, FATCA as we know it, and that compelled disclosure of information of taxpayers, US taxpayers, green card holders, everybody that had a green card or was a US citizen, had to comply. Well, it was the banks that actually had to comply. Now, you know that the system in America is taxation by citizenship, which is very unusual. Not many countries in the world do it. And what it means is if you're a millionaire, a US millionaire, and you live in somewhere like, for example, Borneo or Timbuktu, you still have to file an annual tax return to the American fisc. Now, if you think that's bad enough, then in 2016, we get the Common Reporting Standard. Now, the EU looked at FATCA and they said, we like the look of that. I think, they said, we're going to adopt it. So So they set their usual attack dog, the OECD, onto the issue, and they came up with the Common Reporting Standard, otherwise known to us as the CRS, Automatic Exchange of Information. Now, they say that the purpose of both FATCA and of CRS is to prevent tax evasion. Well, that is true to a small extent. They do catch a few tax evaders. But what it really was after was to expose legitimately harbored offshore wealth in trusts and in corporations, so that in due course the EU, the OECD could tax them. Now, interesting, we don't have full statistics on this. I've looked them up. But in the UK, my home country, which is a good example because it's a residence-based taxation system, which most European systems are. In 2018, okay, and this was without any CRS revelations. The HMRC received 5.6 million records on UK taxpayers' offshore financial accounts. This involved around 3 million UK resident individuals or the entities that they controlled. Nothing wrong with that. However, since 2010, the government has introduced 100 measures to tackle non-compliance, and this enabled HMRC to recover 2.29 billion in lost tax revenues and secure and protect, so they say, over 200 billion. But that was before CRS began. What we can say after CRS is that high net worth individuals are being investigated 6 times over. So that's not a terribly reassuring thing to know, is it? But it's a fact. The former Chief Secretary to the Treasury, a man called Mel Stride MP, he's now the Shadow Chancellor. He said this, and this is very interesting, only 5 years ago. He said HMRC will continue to crack down hard on those who try to avoid or evade paying the tax they owe, as well as those that help them by investing in the latest technology using tough new penalties. You see what they're doing there? They're actually trying to blur the distinction between perfectly legal avoidance and criminal evasion. And this is the theme throughout the whole of the EU, the OECD, and even countries like United Kingdom. They blur the distinction between evasion and avoidance. Now, I've got to move on quickly. You used to be able to get a trust in a company for a few $1,000s, and you were safe in the concept that there would be no intrusion. That is all gone. Now with CRS, FATCA, it's all gone. If you want to keep your wealth confidential, there are not many ways to do it anymore. A lot of people use companies limited by shares. However, they telegraph ownership because there's a registry with the number of shares that are owned by people. So they're not very confidential at all. What you have to do is move to a situation, preferably with a company that doesn't have any shares. And that leaves a company limited by guarantee. A company limited by guarantee, which is what we use and have been using for over 15, nearly 20 years for this purpose of confidentiality, is a company whereby you undertake, by a simple guarantee, to contribute to the assets of the company in the event of its winding up. And usually it's for the sum of about £1 or $10 nominal amount. Then the company is limited by guarantee. And the great thing about company limited by guarantee is that there's no shares. You can't see them. There's no register of them. What you do have is a register that gives you the names of the guarantor members, those who issued signed guarantees, but even they might not sign a guarantee. So how do you know who owns what? You don't. Not with a company limited by guarantee. The other thing is if you want to move or change ownership of the company limited by guarantee, you can do that by an ordinary resolution, and it's done internally by documentation within the company, completely privately. Nobody knows there's been a change of ownership. You are keeping your assets confidential. These companies that we produce are used by high net worth individuals. They're used by ultras with hundreds of millions of dollars of value. We charge 20,000 US to form one and 15,000 US a year to renew them. The value, I think we can move on to the yellow diagram now, if we could. This is the way the company works I've only got 5 minutes left. So Hong Kong Guarantee Company, on the left, you've got the owners. On the right, you've got the board of directors, okay? The board of directors on the right, they have the sole management rights. On the left, you've got the guarantor members. That is if they want to declare themselves as a guarantor member. Many don't. They just stay in the private articles of the company and do not move. So you've got the guarantor members on the left. Now, they have the sole rights to receive distributions, all right? They don't have any management right, but it's the management that decides if there's going to be a distribution. Okay. And many guarantor members, well, actually, they're potential guarantor members because they aren't appointed. There's only one. There has to be a first guarantor member. Okay, a founder guarantor member. What we do is we have two, myself and my business partner, who's also a barrister. We are the guarantors, which very conveniently, courtesy of the OECD, they are controlling persons. So they're courtesy of the OECD, they're beneficial owners. Okay, so we become the beneficial.
Just a moment. I think there is a problem with Jonathan's connection. While we are fixing. Oh, Jonathan, you're.
Hello?
Yes,
Can you
we
hear
can
me?
hear you now. Yes.
Okay. Okay, I've only got how the structure works. We have a quorum director. You'll see in the earlier document, there's 3 or 3 pages, how it actually works. Anyway, so the final clip was put together very kindly by Paulina. She did a very good job. And it summarizes the benefits of using this structure. Do not think that this structure is actually simple. It is, but that's because it's got a long, long period of gestation, which Gordon Fisher and myself put in to make it as simple as it appears. But I can promise you it contains a huge amount of jurisprudence and a lot of very careful. You get 100% asset protection, you get confidentiality, and you become. That is what a lot of people actually want. Perfectly normal persons going about their business day to day. They may have a business, they may have investments, they may have wealth from inheritance. There's all sorts of different reasons, different clients that we have that have different reasons for want. Then we move on. Next slide. Traditional trusts don't work anymore. Okay. It's a very sad thing. They've destroyed.
Jonathan, there is an interruption. Can you hear me? Okay, while we're waiting for Jonathan to reconnect, I will announce our upcoming events. As this season, we have 2 new destinations, which is India, would be B2C events on November 4th. And then in December, we are announcing one more new destination, which is Greece, Athens. It would be a fully B2B event. Which would connect real estate agents and immigration lawyers and consultants. And in September, of course, we are having traditional Dubai and Istanbul events that are made with only 3 days difference for your convenience in terms of logistics and finance. So we would hope to see you at those events. And for next year, we are actually planning Cairo. That project is still under the development, but we've been receiving a lot of requests and we are researching the market. So hopefully next year we would go to Cairo. And I think for now, Jonathan has a problem with connection. So maybe he would be able to answer to all the questions that we received during the Q&A session in the end of the meeting. And if Jonathan is not joining, I think for now we're gonna move on to our next speaker, Natalia Bronina.